Right of a junior advocate. The first and foremost important right of a junior advocate is that he lays his hand on a case file available in the chamber of his senior. A junior lawyer, for improvising his learning capacity, first should read a complete file consisting of I'm talking about High Court, consisting of writ petition, then counter affidavit, then rejoinder affidavit. A complete overview of a case he gets while reading a file wherein the pleadings have been completed. Now, after receiving such file in his hand, he should find a cool place in the chamber, should sit down. Another important thing is, how would he get this file? Definitely with the help of the clerk, which means a junior lawyer should have a good liaison with the clerk. If a junior lawyer asks the clerk to help him complete the reading of a file which is complete in pleadings, the clerk will provide him a case file. With that case file, once the junior lawyer sits in a cool place in the senior's chamber, where there is not much of shortfall, disturbance, interference of the persons coming and going, at that particular place, the junior lawyer first dedicate his entire concentration on the writ petition. Writ petition. Writ petition is a presentation of the case in the form of a story in legal terminology. So, read the entire writ petition as if you are reading a story related with that particular case. And writ petition is also prepared keeping in mind that all the facts are presented in proper sequence. It is like story writing, which has introduction, main body of the story, and then the concluding part. Writing a writ petition is definitely not a difficult task once the documents are organized sequence wise. Let us say date wise. The most beginning aspect of preparing a petition is to first put the documents given by the clients in date wise sequence, starting from either the present date or either from the earliest date. And then once all the documents have been lined up date wise, then, and let us take from the earliest date, then start narrating those documents paragraph wise in your writ petition. Then this is presentation of facts. So entire facts have been lined up from the earliest date to the latest date, which means a complete sequence wise without any break a story is ready in writing. This is narration of facts in a writ petition, in a petition. Now what comes next? We are practicing in Allahabad High Court. Now the grounds are placed After presenting the facts, one has to line up the grounds on which the petition is based, meaning thereby what are the causes, what prompted, what are the reasons for which this petitioner is coming to the court, and what are the illegalities committed by the authority, by the person. All these are set up in the grounds, and grounds are very important and essential, because once a particular ground is not raised, that cannot be orally submitted, or court is not bound to take cognizance of that. Therefore, all the grounds have to be written in there. After presentation of the facts, the grounds are set up. Once grounds have been narrated, then comes the relief which are to be sought in the petition. Framing relief is also equally important, because first and foremost the court reads the relief, because we start as an advocate from the earliest date of the event, of the incident, up to the latest date. Then the grounds, that means which prompted the petitioner to come and approach the court, and then the relief, that means prayer which he is praying before the court for grant. But the court starts from the prayer relief clause in order to get a complete quick overview of the case. So therefore, relief should also be not very elaborate, but must consist of the minute details on which basis the prayer is being made, which means write down a prayer followed by some minute factual details, so that while reading the prayer the court can correlate with the facts also. Now, one prayer is not sufficient, then second prayer can also be made, third prayer can also be made, more number of prayers can be made, but definitely the most important prayer should be put on the first, then the second and third. So in this way a petition is drafted, and the junior lawyer who is seized with the file has to read first the entire petition in order to know what is the story, what are the purpose, what is the relief claimed there. After that, once the first reading is complete, after that he should note down on a plain piece of paper his own notings relating with the relevant paragraphs of the petition. Say, jotting down the paragraph numbers while reading the entire petition, and when the junior lawyer goes back to those paragraphs, then again the contents of those paragraphs will give him insight ki what is the relevant in this case, and then how it has been replied by the opposite party in his counter affidavit, whether it has been rebutted, denied, or partly accepted. So now he turns up the pages of the counter affidavit. Those relevant paragraphs of the writ petition replied in the counter affidavit. The intent of the opposite party also becomes clear, and now it also becomes clear that how the opposite party is denying or rebutting, on what grounds, on what basis. Now, after noting down the paragraphs of the petition, then their reply in the counter affidavit, those paragraphs. Now, basic things have become clear in his mind, that his writ petition is on these grounds, and the opposite party is contesting the case on these grounds. Now, what he has to say in reply to the counter affidavit are written in the rejoinder affidavit. Again, note down the paragraphs, and in this way the entire case file or the facts of the case, including the grounds, including the relief, has become clear in his mind. Now he is thorough with the case, facts of the case. His preparation does not end here. Now he has to consult the Bare Act for those sections which are applying on the facts of the case. Read out those sections slowly. Read out the meaning of those sections and the language used in the Bare Act. Then, in order to become more clear, consult commentaries, particularly for that section. So, the commentaries will make the legal terminology used in the Bare Act very easy and clear also in his mind. Commentaries also refer to the judgments passed by the various courts of the country, and a compilation of judgments of various courts particularly related with that section makes the entire legal picture clear in his mind. Now the junior lawyer has to see what are the judgments on which he can rely or his senior advocate is relying. Those judgments should also be in the case file available. Those judgments should also be read thoroughly. Now, this is the preparation a junior lawyer is required to do with just one case, and after that he becomes confident about the case, and with the help of his short notes he is now in a position to assist his senior in the court during argument. The junior lawyer is also expected to take note of the documents, page numbers where they are attached, and he should also perceive that these documents would be required while argument, so that when the time comes, the senior advocate expects or searches particular document, the junior lawyer immediately helps him to find out, in order to save his time, his distraction, as well as in order to save the time of the court. After assisting his senior ably in that particular case file which he had thoroughly prepared, after giving full ears to the argument presented by the senior and also to the queries made by the court, now the culmination of his preparation is before him. Now he has come to know what is there in the case, what is the stand of the opposite parties, what are the argument of his seniors, what are the arguments of his opponent counsel, what are the queries of the court, and how those queries have been dealt with by the senior or by the opponent counsel, and then what is the final outcome, what orders have been passed. So now, from the writ petition contents up to the final orders, the picture becomes clear. This is definitely one of the best opportunity available to a junior lawyer, provided he exercises his wits as well as his rights well in the chamber, and also utilizes the time very well available to him in the chamber.